Good morning, good afternoon, good evening, everybody. We are making this recording on May 21st, 2026 for the NCDA conference that will be happening on June 29th through July 2nd, I believe. Welcome. This is a session on career development for international students, creative solutions to challenging regulations. And indeed, the current climate right now is very challenging for international students and the schools that host them. I'd like to make initial introductions to our panelists, and we'll start with Nicole Bennett, who's an associate with Fragment. Nicole, do you want to say a few words about your background, how long you've been with Fragment?
Yeah, so I'm an associate with Fragamen. I've been practicing for almost 3 years now. I practice with a wide variety of clients. I do a lot of case types, but my specialty is more in sort of work with physicians, so like J1 waivers, and I do a lot of immigrant petition cases, particularly through EB1 and EB2 national interest waiver pathways, as well as non-immigrant cases. So excited to be speaking with this group.
Great. And we have Kyle Summer, who's a senior associate with Fragment. You want to say a few words, Kyle?
Hi, everyone. Kyle Summer. I'm Senior Associate at Fragment in New York. My team works with a variety of clients, including those in industrial sectors. I also help to lead our team's private client practice, and that covers international students. So I work closely with higher education institutions and international students as they are navigating through their immigration process from their student visas all the way to naturalization.
Thanks. And I'll say I am Robin Ketmer Smith. I'm director of the very new International Student Resource Center that was launched in November of 2025. We are a philanthropically funded organization designed to support international students and scholars in the US, again, in these very challenging times. So we'll go over our agenda. It's pretty broad, but we're hoping in the live session at the conference, we'll have room for questions and answers. But for this recorded session, we're going to go over the definition of an international student, which is not defined by one visa type, give you an overview of the statistical perspective within the US, how many international students we have, where they come from, where they study, a general overview of the requirements, regulatory requirements for those students and the role of the institution. We'll talk about the primary student concerns and issues that they face. We'll certainly talk about the current political and regulatory climate, which is very challenging to our students and to higher education in general. We'll talk about the ways that you as career counselors can support these students and work with your stakeholder offices. And then we'll look at some external resources that you can access. So we'll pass it over to Nicole and she'll talk about the different student categories that you might see.
Great. So I'm going to try to keep this brief and high level, but like Robin said, it's not just one, right? So there are some typical visa categories that we see with students. These are going to be F1 academic students who are entering the US for full-time academic programs at institutions certified by the Student and Exchange Visitors Program. We'll also have J1 exchange visitors who intend to participate in programs with an approved sponsor. And this is going to be usually for purposes such as teaching or conducting research or receiving graduate medical training, among other options. And then M1 students are the vocational or other non-academic programs. So for example, aviation programs, cosmetology programs. There are also several dependent visa statuses. These are going to be the spouses and unmarried children under 21 of principal visa holders. And several of these statuses permit individuals to pursue a study in the US. So just to go through a couple here, we have H4 status is the dependent status for H visa holders, typically an H-1B temporary worker. H4s can apply for work authorization and they get subject to certain restrictions. We also have J2 status, which is the dependent status for J1 holders. They can also apply for work authorization if they wish to. TD status is the dependent status for TN holders, and TNs are going to be for citizens of Canada and Mexico, and these are for individuals who it's limited to certain professions in the United States. TD individuals are not permitted to work in the US, but like I said, they can pursue a study. And then O3 is the dependent status for O1 and O2 individuals. O1s are for persons of extraordinary ability, and then O2 for those accompanying them. And their O3 dependents are not permitted to work in the US, but they can pursue a study. And then just a final few other statuses to mention here, which you might be seeing a lot, include individuals who have pending I-45 adjustment of status application, aka the green card application. Those with pending I-45s can pursue an EAD card if they wish to. You might have students who have pending asylum cases. Those with pending asylum are legally permitted to remain in the US while their asylum case pens. They can also apply for work authorization after a certain amount of time passes since the asylum application has been filed. You could also have students who have been admitted as refugees in the US or paroled into the US for temporary periods for humanitarian reasons. And temporary protected status, or TPS, as we have listed here on the slide, is a common status you also might see, maybe less so these days, but these are for individuals from certain countries which have been designated for TPS as a result of conditions that make it unsafe in the home countries to return. And with these last few statuses that I've been going through, you often will see them in tandem with another non-immigrant status. So one of those visa categories that I previously mentioned. So for example, you might have an F1 student who has a pending asylum application as well as a grant of TPS. Or you might have a student who is in H4 status but has a pending I-45 application. So overall, many statuses you likely see and work with every day that can permit individuals to pursue study in the US.
Thanks, Nicole. I will say too that there are a couple of visa statuses that generally will not allow a person to enroll in a degree program. That would be an F2 dependent of an F1, and generally a tourist visa, B1, B2, or a tourist waiver. So those are generally not allowed to study in full-time degree programs. So we'll look now at the statistical sort of circumstances in the US. There's a great report that comes out usually for students. It comes out each spring called Open Doors, and that's from IIE. And their last numbers, there's usually a year-long lag. Their last numbers for the 24-25 academic year, there were 1.2 million international students in the US, which, despite the climate, was an increase of 4.5% overall, which was gratifying. The problem is the new international student numbers. So the numbers of students coming initially to the US to start in the fall of 24 was down 7%, 7.2%. They anticipate seeing continued declining numbers over the next year or two. The top 10 sending countries were India, China, South Korea, Canada, Vietnam, Nepal, Taiwan, Nigeria, Bangladesh, and Brazil. The top fields of study, sort of unsurprisingly, math and computer science were 26% of students. Engineering was 18%, business and management 13%, Physical and life sciences, 8%, and social sciences, 7%. The organization used by most schools' immigration advising offices is called NAFSA, the Association of International Educators. And NAFSA has a really great economic value tool. So based on these numbers, they extrapolate how much international students provide to the US economy. And overall, again, for 24-25, they contributed $43 billion to the US economy and created or supported over 355,000 jobs within higher education. This data is also available at the state and district level and at the institutional level. So if you're curious about where your school lies on this, you can access this information on NAFSA's webpage. I will say specific to this webinar, international students are allowed to apply for a post-graduation work authorization called OPT, which we'll talk about in a little bit. And of those 1.2 million international students in the US, almost 300,000 were approved for this post-completion work permission. So it's very common for students to move from graduation to this work permission, and they're going to be looking for jobs. That 300,000 number was an increase of 21% from the year before, so a very, very popular program. Okay, so now we'll go to Nicole again. We'll talk about maintenance of status requirements.
Great. So I'm going to focus here on some of those main student visa categories that we talked about, and then a general sort of wrap up. But to enroll non-immigrant students in their programs, schools should be certified with the Student and Exchange Visitor Program. You should have designated school officials or DSOs, and access to SEVIS, the Student and Exchange Visitor Information System. When we're looking at F1 students, like I had said, these students are enrolled in a full-time program or course of study that culminates in a degree, a diploma, or certificate. And DSOs should be working with students to ensure that the student has a Form I-20, which authorizes that student to engage in that program, and amendments or extensions of it as may be necessary. When it comes to employment authorization, typically for F1 students, they can accept on-campus employment and off-campus employment after their first year. And that's going to look like one of the practical training options, of which there are 3. So to briefly cover them, we have CPT or curricular practical training, which can be either full-time or part-time, should be integral to the student's major or part of the program of study. Students need to be authorized for CPT, but they do not need to obtain an EAD, an employment document from USCIS. OPT, on the other hand, is related to the student's major course of study, and it does require a student to have an EAD document. This can be either prior to completion or post-completion of the program. I will note for students who have already completed 12 months of full-time CPT, they're ineligible for post-completion OPT at that same degree level. And students can apply for 12 months of OPT at each degree level. So 12 months at bachelor's, master's, doctorate. And then some individuals may be eligible for what's called the STEM OPT extension, which is an additional 24-month extension for those with qualifying STEM degrees and are seeking training related to that degree. So DSOs should ensure that students have those Form I-20s that reflect those periods of CPT and OPT. J1 holders, like I said, these are students, exchange visitors who are engaging in a program with a sponsor, and it can be for multiple reasons. Like I mentioned, a lot of these involve work. And so the individual is authorized to work incident to their status with their sponsor program. And they're limited to the activity in the program that's listed on the form DS 2019. So for F1s, they'll have the form I-20, J1s will have the form DS 2019, and they should work with their program in order to extend it or amend it whenever it might be necessary. One thing I want to note that some of you may or may not be super familiar with is when it comes to J1s, what we call the 2-year home residency requirement, where some certain J1s are going to be subject, and it's one of 3 reasons usually. If the J1 received graduate medical training, if they received government funding, or if they participated in a program that is listed on the exchange visitor skills list, they will be subject to what's called the 2-year home residency requirement. And they will either have to pursue a waiver of that requirement, of which there are multiple avenues and options for those, and we don't have time to cover all of them today, or they have to go home for 2 years and fulfill that requirement before they're going to be able to pursue an H-1B visa or a green card pathway. There's a bit of a Canadian exception because Canadians are visa exempt. Canadians may be able to get into H-1B status before waiving or fulfilling that requirement, but in general, something to keep in mind with J1 students. And then just a couple last notes here. For both F1 and J1 students, this requires that an individual have non-immigrant intent. So that means that they intend to depart the US after their temporary period of stay. There's currently guidance on USCIS that an approved immigrant petition or labor certification does not on its own destroy a student's ability to show that they have non-immigrant intent. However, we'll talk more about how we're seeing things change at such a rapid pace these days. So I say that with some hesitation of that's our current guidance and it can change. But to wrap up, generally speaking, for all students, regardless of what status they're in, the key importance is that they are not engaging in any activity that they are not authorized to do so. They should know that they should notify their programs of any changes, so a change in their address or change in program activity. And overall, maintaining a student status is essential to ensuring A, that they can continue to remain in the US and participate in the program, and B, to protect their future options if they want to change status later on or pursue an adjustment of status green card application.
We'll talk about
So we're
primary
now
student.
going,
Yeah, sorry, I was just passing it to you, Kyle.
thanks, Robin. So we're going to talk through some of the primary concerns that we see from international students. International students really face multiple obstacles and potential barriers as they move through their academic programs and their careers that aren't applicable to students or recent graduates who are U.S. citizens. So these, obstacles and barriers can really be a source of anxiety for international students. And it's important for you to keep these in mind as you're advising international students because these issues can really impact their job search and their potential career opportunities. So just going through the list here, the first, funding and financial documentation. So focusing on international students who are in those more common categories like F1 visas, they do need to show that they can fund their education. So that's including tuition, living expenses, travel costs. That's going to be part of the application process. The international students aren't eligible for federal financial aid, so they often face financial pressures that U.S. citizens might not have. That is going to impact their sense of urgency and even anxiety around finding employment while they're in school and then as soon as possible after graduation. The visa process itself can be very complicated. It's rarely easy. It's not automatic. It's certainly not guaranteed. Even though they might have multiple pathways, as we discussed earlier, they might have the more traditional international student route with the F and the J, or they might have some other status. Either way, there's going to be a number of steps and processes that they're going to need to go through. So if we're looking at international students in those more traditional categories like an F1, there's multiple steps to the process. They're going to need to secure initial paperwork from their sponsored school. They'll need to apply for the visa stamp at the consular post in their country of citizenship. They'll need to appear for the visa interview, pass any required security checks, and then ultimately need to be admitted through customs and border protection at the border, which also isn't guaranteed just because they have the visa in hand. They're also going to need to demonstrate what's called non-immigrant intent. And this is basically that the international student needs to, that's applying for an F1, is going to need to confirm that they're coming to the US temporarily, that they'll ultimately depart the US at the end of their program, and show ties to their home country. And this can provide a little bit of tension, certainly as you're advising international students, because on the one hand, for their immigration status, they may need to show that they're here temporarily, but then at the same time have sort of longer term plans for remaining in the US and ultimately pursuing a career in the US. So helping them navigate that and partnering with other professionals that can help them navigate through that tension is important. Security clearance and checks. So this is becoming increasingly common. Where we see this, the step where we see this in the visa process is typically at the consular post when the students are applying for their visa stamps. And particularly for students from certain countries, like China, we see a very high rate of security checks. It's also known as administrative processing. In addition, students who might have some sort of legal issue in their background, like an arrest, or maybe some social media activity that the US government considers to be suspicious. Those are all things that could place a student into these additional security checks. Now, once a student is placed into that process, that administrative processing, there's really not much that can be done. It's really just a waiting game until the government goes through the necessary steps and processes to confirm that student isn't a security risk. And we often don't have a reason or rationale for why that student might be undergoing the administrative processing. So ultimately, it's very important that students, particularly from certain countries, and if they have any legal issues in their background, that they take a lot of care and caution and get the necessary guidance before they travel internationally, so that they can mitigate any risk around delays in their return to the US. So the administration has been placing a very high level of scrutiny on international students overall. This really crosses the board of international students from all countries. We certainly saw this last year with a lot of the visa stamp revocations, as well as the SEVIS record terminations, which has calmed down quite a bit now this year. But where we're still seeing a high level of scrutiny is around citizens and those born in certain countries. So we'll talk about this a little bit more in the next section, but there's essentially some executive orders in place that limit travel to the US, or place a pause on the adjudication of certain immigration filings for individuals who are born or citizens of certain countries. So again, it's going to be very important to be mindful of a student's country of citizenship and country of birth as they're moving through the immigration process. So as far as finding internships and postgraduate work, and as you're advising, international students on this, again, there's going to be additional barriers that international students are going to face that their US counterparts wouldn't. So a couple things to keep in mind. a lot of times the internships and work need to be related to the degree field. They don't quite have just sort of a free-for-all or open market situation where they could explore, multiple types of internships and work. It's typically going to have to be related to their degree field. It's going to be very regulated. So oftentimes that employer is going to need to provide certain details to the sponsored school so that the school can complete the necessary paperwork. The student might, be required to perform a certain number of hours, either a maximum or minimum. Many are not going to be eligible for certain types of positions. For example, if the position requires U.S. citizenship or a green card. A lot of employers are going to be hesitant to sponsor. We're certainly seeing that in the current environment with increased fees, increased backlogs, risks that a student or an employee might not be able to travel to the U.S. after international travel. Those are all putting a bit of a chilling effect on hiring. And so students might have to do a lot of convincing as they're moving through the immigration process and interviewing with their employers. There are often relatively limited pathways. The H-1B is a very common pathway. We'll talk about that a little bit more. And for some students, they might have other pathways that are related to treaties from countries that they're from, or they might be an individual of extraordinary ability where they're working in a very unique maybe area or in-demand field. But generally speaking, the opportunities are going to be more limited than their U.S. counterparts. And there's also going to be limitations in terms of their unemployment, like how long they can remain unemployed while still maintaining their status. So it's going to be important to be mindful of that, advise them around that, and essentially ensure that they are employed and in a valid internship as they move through the process.
Thanks, Kyle. I think to emphasize all of these pressures result in students feeling a great deal of uncertainty. And the bad news is we can't really solve that right now. We can just support with the best advice we can and to help them in any way we can. But that uncertainty is really a difficult thing for them to face. Nicole, I think this one is for you.
Yeah. So on that note, I'll transition into some of our hot topics today. Like Robin said at the beginning, we're recording this on May 21st. So by the time we get to our in-person session, there could be some changes. But top of mind, I'm sure for a lot of people, are travel bans and restrictions. Like Kyle had said, there was a December 2025 proclamation, which outlined full travel bans for nationals of 19 countries, plus individuals with documents from the Palestinian Authority, and then a partial travel ban for nationals from 20 additional countries. So the full travel ban restricts all entry of all nationals from those countries, while the partial travel ban restricts the entry of immigrants or of nationals who are entering on an immigrant visa, a B visitor visa, or an FM or J student visa. There are some exceptions to the travel bans. We won't go through all of them, but to name a few, green card holders in the US are exempt from the travel bans, as well as dual nationals who can travel on passports from non-designated countries. Tied to these travel bans comes the current pause on USCIS adjudications. So for the last several months, USCIS has suspended the adjudication of cases for individuals who are either nationals of or were born in one of the countries subject to either the full or partial travel ban. As you can imagine, this is impacting a lot of people and a lot of cases right now. There are very limited exemptions to the adjudication pause, and we continue to kind of see how this is being implemented. We had seen semi-recently USCIS sort of like discreetly updated their guidance to exempt medical physicians. So cases associated with medical physicians they said the adjudication pause was lifted. We still haven't really seen how that's going to play out, and we'll continue to see how these exemptions are being processed. So, we might have further updates in July. Also, over the past year, we've just seen, as Kyle said, a heavier scrutinization of cases, and particularly an increase in what's called a request for evidence, or RFE, from USCIS, where they're pushing back on a case filed and asking for more evidence. We've seen a lot of RFEs increase across the board, particularly with some immigrant petitions through the National Interest Waiver pathway. We've also seen a rise in these biometrics RFEs, where individuals are getting an RFE and they're being requested to go in and provide biometrics in order for USCIS to then continue processing the case. So delays on top of more delays is kind of the theme here. But another big topic that's on a lot of people's minds right now is social media and social media vetting. All foreign nationals are subject to more stringent security checks at the border and when applying for immigration benefits. And this includes social media vetting. And social media vetting, particularly for student visa applicants, has really been enhanced. So we are always, advising our clients when it comes to appointments at consulates abroad to obtain a visa that their social media is set to public. We advise clients to always have, be mindful of what is being posted on social media. You don't want to post anything that the US government could misconstrue to be in support of violence or extremism. Officers are really looking for derogatory information on social media and looking for any indication of hostility towards the US government or its citizens, any indication that somebody has supported or aided an organization the US deems to be a terrorist organization or a threat to national security. I think last April DHS had said it was considering anti-Semitic activity on social media as grounds to deny an immigration benefit request. So definitely something, us as attorneys are keeping a close eye on, and something to keep in mind when advising students, particularly when it comes to international travel plans or visa appointments abroad and when applying for benefits. And then really quickly, I did want to touch on the duration of status rule, or more appropriately labeled the loss of it. Historically, F&J students had been admitted for duration of status, meaning they didn't have to apply with USCIS to extend their status. Like I said, they would work with their programs to amend or extend their I-20 or DS-2019 forms as needed. However, earlier this month, a final rule was submitted by DHS to essentially do away with this duration of status, and require individuals would be admitted for a fixed period of stay, and they'd be required to extend their status. I don't want to get too far into it. We don't yet have the final rule, but we do expect it shortly. And so we'll have further details once we get that.
Right. Thanks, Nicole. I will say there is some litigation going on against the USCIS adjudications, and I think a couple of cases have been approved for the plaintiffs who file with those cases. So this doesn't affect, the thousands and thousands of students, but it's good news for a couple of dozen. And it's also good that they are succeeding in the court. So that's great. Kyle.
Just moving along to some of the additional sort of hot topics. So when we're looking at challenges to F1 OPT, so really all F1 international students wishing to remain and work in the US after graduation heavily rely on the OPT and STEM OPT program as really a bridge between their international student status and then longer term pathways in the US, like an H-1B. So what are some of the trends we're seeing around that? So certainly increased scrutiny, so additional requests for evidence, as Nicole mentioned, and well as that might be related to their eligibility, or it might be related to them being from a travel ban country, and sort of working through that. There's also a concern that there could be an increased risk in workplace audit. So there's a significant amount of resources now being dedicated to resources towards auditing employers in really all immigration categories. And this could include F1 STEM OPT, for example, because there are those employer requirements to complete a training plan, for example, and be enrolled in E-Verify, et cetera. So those could be, we could see an increase in those audits in the future. And then potential elimination of the program altogether. This is something that's been sort of floated, I guess you could say, in the past. There is certainly comments from current administration officials, lawmakers, around ending the OPT program altogether. I do think that will be potentially an uphill battle there. There definitely could potentially be litigation again because so many employers rely on this, and schools rely on it as sort of a benefit for their students after graduation. So that really would have a drastic impact, a drastic change in terms of that flow and immigration pathways from international student status to a more permanent status. Cap-gap understanding is often a source of confusion. So cap-gap, how it functions, it's a benefit that really helps facilitate the transition from F1 international student status to H-1B status, which is probably the most common pathway that international students pursue after graduation. So the way it works is H-1Bs aren't effective until the start of the next fiscal year. So that's going to be on October 1st. But in many cases, you have an F1 student whose OPT is expiring before that. So it might be expiring in July, for example. So what cap-gap protection allows is that as long as the H-1B cap petition is filed prior to the F1 OPT extension or the F1 OPT expiration, then that student's going to be protected for a period of time between when the F1 expires and then when the H-1B ultimately becomes effective. That cap-gap duration has been extended now. It actually goes all the way until April 1st of the next year. So that does give some protection for some of those longer pending H-1B cases. But it's only available when students file as an automatic change of status from F1 to H-1B. It also only applies on the basis of a filing of the H-1B petition, not on the H-1B cap lottery. So the way the H-1B cap process works is the employer first submits the student in the H-1B cap lottery, and then if they're selected, they have about 90 days to file the actual petition. The cap-gap protection only triggers at the time of filing the petition. There's been a lot of changes in the H-1B process this year. So the first one being around the $100,000 fee, which came about by executive order in September of 2025. That really created a lot of chaos and uncertainty at that time when it wasn't clear exactly what that meant in terms of who would be subject to that fee, how that fee would be paid, when in the process it would need to be paid. And so we have a lot more information now, and it does turn out that the scope of that fee is quite a bit more limited than initially anticipated. Basically, where it's going to apply is where the beneficiary of the H-1B is physically outside the U.S. At the time of filing and basically needs to consular process that H-1B, secure the visa stamp, and enter the U.S. for F1 students who are physically present in the US and file as an automatic change of status, that 100,000 fee does not apply. So that's been a source of confusion that we've been working with employers to make sure that they understand that and that they file their CAP cases accordingly so that they can avoid that $100,000 fee. But where it gets a little tricky and can get complicated is where in certain situations where you can't file as an automatic change of status, for example. So if you had a student who had failed to maintain their status or violate their status in some way, they would likely not be eligible for that automatic change of status to H-1B. Rather, once their H-1B is approved, they would need to take it to the consular post in their home country, apply for the visa stamp, and then use that to sort of activate the H-1B. Sometimes there are things in students' background that they're not aware of or that we're not aware of. So what essentially happens is we file the H-1B. If the government thinks they're subject to the fee, they issue a request for evidence, and then they would ultimately need to explain why the fee doesn't apply or pay the fee as part of that request for evidence. The weighted lottery selection process really did change the game, so to speak, around the H-1B cap lottery. The way it functioned this year was that there was a weighted process based on the salary level of the H-1B beneficiary. There are basically 4 levels in terms of wage levels for each occupation that could align with an H-1B. And basically, students who are, any applicants in the H-1B cap lottery who were being paid at a higher wage level had more chances of being selected in the lottery. They were basically, the lottery was run according to wage level. So a level 1 wage would get 1 chance in the lottery, level 2, 2 chances, and so forth. And so what that did was it resulted in really a much higher selection rate for individuals who are at those higher salary ranges, but it tended to have a more detrimental impact on F1 students, many of whom are more entry level, starting earlier in their career, so may not be paid at those higher levels, so would have had fewer chances in the lottery. We're awaiting to see, we're starting to see some requests for evidence come in around the H-1B process. We're anticipating some that will be around the weighted lottery system and the minimum requirements for the role. So we'll sort of stay tuned for that. We're also seeing requests for evidence related to individuals who are from travel banned countries and basically having to explain to the government why the individuals are not a security risk and should receive the H-1B. There's always possibility for additional lottery runs. If there is one, it will be later in the summer. I think it's a little less likely this year. I think most employers who submitted H-1B cap lottery registrations are likely and poised to actually follow through and file the H-1B cap petitions since their individuals are largely in the US this year, but we'll have to wait and see on that. As far as this other point is really related to the uncertainty that Robin mentioned. The landscape is rapidly changing. Students are trying to plan for their long-term careers, and that's really challenging in this environment. And decisions that students make today could impact their chances long term. So certainly an overstaying, kind of getting desperate and overstaying a visa. Or working without authorization, or if they were to have an arrest of some kind, those could potentially have long-term impacts that we're not entirely sure what those impacts are today. Because the situation is changing, there could be a new executive order in the future, a new regulation. And so at this point, it's really about sort of helping to mitigate risk where we can, advising students on what's known today, and being a bit more conservative and risk averse where possible, because we do anticipate that the landscape will get stricter before it gets more lenient in a potential new administration.
Thanks, Kyle. And the last bullet here You know, that this has been in the news quite a lot, but students are feeling this threat to their ability to exercise their rights to free speech. And in fact, that's being inhibited. They have a great deal of anxiety about this, about the current political and regulatory climate, and finding ways to reassure them, but also advise them to be cautious, especially with, as Nicole said, social media posts. They're being looked at all the time. These trends, we'll go to the next slide here. These trends are continuing. The ways that you can offer support for your students are really trying to be sensitive to the circumstances they face. Ensure that whenever this new loss of DS rule becomes final, which we anticipate quite soon, I would estimate within the next weeks, that you have good information about that. It sounds pretty technical, but essentially what it does is it gives USCIS, a government immigration agency, the right to make academic decisions on behalf of your student. That's very restrictive and it's very new. The DS notation goes back decades. And never has the government had that ability to govern when a student can change their program, when they can move to a new degree program, when they can have an extra term to finish. So try to make sure that you and your institution have really good information about that. Looking into CPT is important. Curricular practical training is a really great tool for students when they're looking for internships, especially at a point where higher education is emphasizing the importance of experiential learning. Your international students are at a disadvantage. If there's a way that you can work with your curriculum systems office, your registrar, and your immigration services office to make sure you have course offerings that comply with the requirements for CPT, you're going to make it more likely that a student will have the ability to get that experiential work permission. So looking at CPT, and then reviewing your academic programs for STEM OPT eligibility. So STEM OPT is allowed an additional 24 months of work permission after graduation. So that would be a total of 36 months. It's only allowed for certain zip codes. So when the academic program is assigned a zip code, that zip code is what determines whether or not STEM OPT is available to that international student. So looking at those codes at your curriculum systems level, when I was at the University of Georgia, we're a system school, so we actually had to go back to the central system office to look at zip codes. It's not something that can be changed for one student, has to be changed for the whole program if you are determining that it is in fact a STEM program and needs to be reassigned a different zip code. Kyle, do you want to talk about OPT, STEM OPT?
Yeah, thanks, Robin. So as career development professionals, it's going to be really important to be clear on the distinction between F1 OPT and STEM OPT, since this is going to be a program, again, that many of your international students are going to rely upon. So in general, STEM OPT is going to be much more limited or restricted. So, it's only available to designated STEM majors. The employer that the student is working with must be enrolled in E-Verify. There's a training plan requirement, the Form I-983, that's going to need to be completed. There needs to be a valid employee-employee relationship, so a bit more limitation for your entrepreneurial type students, potentially. It needs to be paid employment. So where this comes up in particular is for your students as they're transitioning from OPT to F1 OPT, or from OPT to STEM OPT. So they might start following graduation with that 1 year of initial OPT and be pursuing some opportunity, some employment based opportunity, or maybe a volunteer opportunity. But once they transition, once they have exhausted that 1 year and are ready to transition into STEM OPT, they need to make sure if they're going to continue with that opportunity that it complies with the STEM OPT regulations because they are fairly distinct. Ensuring that students have access to accurate and timely advice on CPT and OPT applications. So as we've talked about, the rules are changing, and they're changing pretty quickly and pretty dramatically. So really staying in close contact with your international student office, partnering with organizations or immigration counsel who are sort of in the weeds of some of this and are really up to date on some of this is going to be really important as you try to advise and navigate international students through the process. For your students who are very entrepreneurial, particularly business students, master's degree business students, it's important to kind of keep in mind some of the do's and don'ts, what they can do with OPT versus STEM OPT to ensure compliance. So generally speaking, forming a business does not require work authorization. Those initial steps towards setting up the business, establishing the corporation and whatnot, typically does not require work authorization. But once it crosses the line over into operating the business, that's going to require work authorization. And sometimes that line can be a bit of a gray area from moving towards the initial forming of the business and operating the business. So particularly now, where the government is really looking at ensuring that students are maintaining valid status, it's going to be very important that students understand that line and manage their risk accordingly. And again, as we mentioned, there's going to be a little more flexibility for students on OPT to potentially pursue those entrepreneurial endeavors than there might be on STEM OPT.
Thanks, Kyle. I'll give a little plug here. The International Student Resource Center recently did a webinar with a really great immigration attorney, Efren Hernandez, on entrepreneurial activities and how they intersect with F1 student ability to work. That's linked on our website if you want to go have a look at it. Very quickly, a few more ways that we can support the students. Look at those employer relationships that you have through your career services offices and really promote these opportunities with the employers as well, so they understand what it's going to take to hire these students and realize that it is possible. What we really don't like to see is those employers who put out an internship announcement or a job announcement and, must be a US citizen to apply. We'd really like to educate the employers that there are ways that they can hire great international students, and to make sure that there is cooperation and great communication between career services and the immigration services office on your campus. Make sure that there's information flowing both ways and that you're working together to support those students. Let's see, maybe Kyle, you can do the last three.
Sure. So some of your students just, might not have a path forward, right? Maybe they've exhausted their F1 time. They didn't get selected in the H-1B category. So it's going to be important to work with them where you can to find some sort of solution. We definitely encourage students to think long-term, right? So some students, they've invested a lot of time, money, energy in their U.S. education, and they're sort of desperate to stay, and sometimes make poor choices around, staying in the U.S., working without authorization, and we want to do all that we can to avoid that and to discourage that. So doing things like helping the student enroll in another degree program, or helping to facilitate a career opportunity outside the U.S. That may then open up additional pathways in the future for them to return to the U.S. as an intercompany transferee. There's usually going to be some sort of solution if students take a big picture approach, think long-term, look at their long-term career goals, as opposed to kind of looking from a short-sighted perspective of where they are today. So finding ways to, work with across campus with stakeholders. It's sort of as Robin mentioned, our most successful academic institutions when it comes to working with international students is when the various offices that interact with international students and support them are all aligned. So your international student office, your career services office, your international student groups. If there's a separate, student legal services um, office. Having all of those aligned is going to be really important so that you can best ensure that your international students are happy, have good well-being, academic success, future career success. And as career development professionals, you're a critical part of that equation. So, you have the ability to kind of take the lead, take ownership of that, and help facilitate the coordination between those offices and groups where you can.
Mhm.
And then finally, just exposure to external organizations and companies. Fragment partners with Interstride, for example, which is as a great resource that many schools subscribe to. If you're not aware of whether your school subscribes or not, check with your international student office. They may own that partnership, and see if you are members or consider joining Interstride, because it's a great resource. Here at Fragment, we partner with Interstride and conduct a lot of webinars, information sessions for international students.
Thanks, Kyle. We'll talk now just about the resources that we're offering. Kyle and Nicole can talk about immigration attorneys as resources becoming more and more important for students to have access to that legal counsel because it's so complicated now.
Yeah, absolutely, Robin. So, as part of that ecosystem, we talked about the International Student Office, Career Development Office. Having immigration counsel at hand is really a key component of that. And the purpose of an immigration counsel that has expertise in international student issues specifically. So, your international student advisors are going to be experts on F1s, typically experts on J1s, but they may not have the deep knowledge on kind of post-graduation issues, or maybe crimmigration issues when a student is arrested and how that could impact their immigration status, or maybe students on dependent visas or humanitarian statuses. So having an immigration counsel who can help kind of bridge that divide between the expertise of the International Student Office and the expertise of you all as career development professionals can really help to build a robust support network for your international students. And here at Fragment, we have number of resources for international students, and work with multiple institutions to help facilitate that through information sessions, through immigration action plans for students, and to just overall make sure that they are both compliant and that they are fully aware of their immigration options after graduation.
Yeah, and I mean, I'll just echo exactly what Kyle said and just add, when we work a lot with students, they're thinking long term, and we always say it's never too early to think long term. So partnering with Immigration Counsel, we're here to support and looking at those bigger picture items. And in such a dynamic, fast-paced world that we live in right now, Immigration Counsel is just an added benefit for you and your students to keep up to date with good and real-time information.
Your international student office, may already have an immigration partner that they work with, so that would be a good first step to consult with. And then also immigration attorneys who are attending conferences like this one with NCDA, or other conferences like NAFTA, are going to be helpful resources, because you'll know that those attorneys do have that international student specific experience.
Right. Thanks, Kyle and Nicole. And I will say this International Student Resource Center that we built up the last 6 months is available. It is free. Like I said, it's philanthropically funded by 6 or 7 very generous organizations. Why now? Because it is so challenging. The goal of our funders is to counteract the really hurtful and hateful messages that are coming out from our government about international student, to try to allay some of that uncertainty. In particular, we have a help desk where students, scholars, advisors can submit questions. And we have a team of about 8 really well experienced immigration attorneys who can answer within 1 business day. So if you have questions, we're available to help. So take a look. It's internationalstudent.us, not .com. That's a different site. But we are happy to help. And thank you so much for joining us today. Thank you, Nicole and Kyle. Appreciate you being here for this recording and looking forward to the in-person session in a month or so. Thanks so much.